This is wasting the court's time, and it's wasting plaintiff's time.
I don't need to.
What?
I don't need to talk about it. I thought you were asking me.
Well, the problem is maybe I'm a bit.
This case does not ease into drama. It detonates right out of the gate. When Judge Simpson opens by calling this a waste of the court's time, that is not casual frustration. That is a warning shot. Judges are measured by design, so when you hear language this blunt at the opening seconds, it tells you something important. Patience is already gone, and credibility is already under scrutiny. What we're watching here is not just a landlord-tenant dispute anymore. This has become a procedural mess, layered with miscommunications, questionable filings, and now, serious ethical concerns. The court isn't just annoyed, it's alarmed. Time in court equals money, and wasted time means someone is about to be held accountable for unnecessary costs. As this unfolds, pay attention to who actually knows what, who claims ignorance, and who appears to be acting behind the scenes. Because in court, confusion is rarely accidental. And when filings appear that no one claims ownership of, that's when judges start asking questions that can lead to sanctions, contempt, or worse. Right now, the big question for you watching is this: if something gets filed on your behalf without your knowledge, who should be responsible? The attorney or the client? Keep that in mind as this case spirals.
Good morning.
Good morning.
John, I'm not sure about that case. Good morning, Your Honor. Steve Otherby on behalf of Plaintiff Fixing Housing, 401k.
Erica Ward.
Aaron Wood.
Thank you. You may be seated. Okay, folks, where are we on this case?
Your Honor, we're here for our 7th hearing in this matter. If you recall,
And you might be to 10 by the time you guys get done, but go ahead.
Your Honor. But at the last hearing, we had our motion. It was a motion hearing.
Yes.
And you stopped it, and it essentially became a settlement conference.
Yes.
Nothing came out of that. It didn't settle that day. How about that? After that hearing, the tenants sent 2 notices of repairs, which one of them matches one of the pending motions that's before you. Our response to that motion would apply to the second notice of repairs. And Your Honor, also, I learned on Friday afternoon, I received an email from Donna Tope with the filed correction of defendant's response to plaintiff's motion for summary disposition that was filed on their behalf.
You received what?
This is a critical turning point, and it might sound minor if you're not familiar with courtroom procedure, but it's not. What just surfaced here is a corrected filing tied to a motion for summary disposition, which is essentially a request for the judge to decide the case without a trial. That's a big deal. Now here's the issue. Courts run on strict rules. Once a judge orders a pause, a moratorium, on filings, nobody gets to quietly sneak paperwork back into the record. You need permission, you need transparency, and you absolutely need proper service so the other side isn't blindsided. What the plaintiff's counsel is flagging here isn't just a technical error, it's a potential procedural violation. The filing is dated one day, stamped another, and received days later, right before a holiday. That timing matters. It increases costs, forces rushed responses, and undermines fairness. And notice the judge's reaction. He isn't asking about the substance yet. He's asking, why does this exist at all? Because before a court even considers what a document says, it must decide whether it should exist in the record in the first place.
I received an email from Donna Tope with what appears to be, and it's a filing. It's called Correction of Defendant's Response to Plaintiff's Motion for Summary Disposition that was filed on their behalf.
Is it in here? I did not. That was on Friday you received it?
I received that on Friday afternoon. And Ms. Tope.
No, I got there.
I may be able to that.
Your Honor, I also have the email from Ms. Tope, which it appears like she's still representing the witness.
Okay, go ahead. I scanned it, but it's basically her affidavit, it looks like.
Your Honor, it appears to be a supplemental corrected affidavit by Ms. Tope. It's blamed on a computer glitch from the previous affidavit that she filed. in response to landlords MSD. I have many problems with the filing. At December 19th hearing, you ordered a moratorium on plaintiff's motion or party's motion practice, and it does not appear that they asked you for leave to file this corrected response to our MSD. Filed this on behalf of the wards, even though she was required to withdraw from this case, and she did withdraw from this case. Tote's filing in her email, which again, I have the email, which demanded a copy of landlord's MSD. So it appears that she's still acting as counsel on behalf of the tenants. And tenants are responsible for their filings. They can't plead ignorance to this. The filing and Tote's affidavit are dated January 8th. That's 2 days after our last hearing. The proof of service falsely states that it was filed with the court and served on landlord on January 8th. The court stamp shows that it was actually filed on January 14th.
This is where things start smelling bad. Procedurally speaking, dates are everything in litigation. When a document claims it was filed on January 8th, but the court stamp says January 14th, that discrepancy immediately raises red flags. Courts rely on timelines to determine fairness, notice, and compliance with rules. If a filing is misdated, intentionally or not, it can mislead the court and prejudice the opposing party. And here, it's not just the date that's questionable. It's who filed it, under what authority, and whether they were even allowed to file anything at all. The plaintiff's counsel is also pointing out something subtle but important. Even if tenants claim ignorance, parties are generally responsible for filings submitted on their behalf. That's why judges take representation seriously. You can't just say, "I didn't know," and expect that to erase procedural consequences. So here's the tension building. The court must decide whether this filing is unauthorized chaos or something the tenants should still be accountable for. Either way, someone is in trouble.
And again, I didn't receive a copy of this filing until Friday afternoon, right before MLK holiday. Your Honor, I can address the substance of this corrected affidavit. It appears that she's still making the same residential lease argument that, as you recall, Your Honor, you warned the tenants that if they continue to make this argument that they could be subject to sanctions. They made the argument, and they continue making the argument.
Let's deal procedurally, I guess, before I get to the substance of it.
I can address the substance.
Well, yeah, I know you can, but I want to try to figure out why this is here.
Okay.
You want me to address that?
Yeah, please.
I had no idea as to procedurally. All I did when we left is said, your affidavit was like glitched, incorrect, you've got stuff. And so I didn't ask her to do anything. She's not representing us. She just said, "Hey, just so you know, I fixed my affidavit." And that's as a witness, not as a lawyer.
This explanation sounds reasonable on the surface, but legally, it's shaky. The moment an affidavit is submitted as part of a motion for summary disposition, it is no longer just a witness statement. It becomes evidence tied to legal advocacy. And that distinction matters a lot. An attorney who has withdrawn from a case cannot continue filing documents that influence active motions, even if they claim to be acting only as a witness. Courts look at substance over labels. If it walks like legal advocacy and affects legal outcomes, it's treated as such. What's happening here is confusion layered on top of risk. The tenants say they didn't authorize it, the attorney isn't present to explain it. And the judge is now stuck trying to untangle who is responsible for something that never should have happened this way. Ask yourself, if you didn't read something filed on your behalf, should you still benefit from it? Or should the court throw it out entirely? That question is looming, and it's about to matter a lot.
So what she says in her affidavit as a witness, I didn't have anything to do with it, and I didn't even realize it would be an issue. I told her that her affidavit was not correct at all, and that is how she followed up. She is not representing us, Your Honor.
This doesn't make much sense to me as to why she did this. She's not here to answer.
I have the email, which it appears that she's still acting on your behalf in this case.
Hold on a second. Can you show, were they CC'd on that, do you know? Or can you show them and then I want to see the email?
I don't think it's a refiling. I just think it's a refiling of the original one with the correct affidavit. So I don't know
Okay.
the specifics of the law, but to me, it just looks like a corrected, something that she had already filed. Actually, the correction to what we filed.
Mr. and Mrs. Ward, I guess it would be one thing if you had filed something saying, here's the corrected affidavit. And if you went to Ms. Tope and said, this is all wrong, here's the corrected affidavit, and you guys sign off and you file it. That's one thing. This is a whole other thing along when you take it in the context of that email. I don't know why she's still communicating with counsel. It doesn't make any sense to me.
I did not ask her to do that at all. And I understand what you're saying. It would have made sense for her to correct her affidavit and hand it to us so that we could submit it. I have no idea why she did that.
So here's where we get into another thing. She filed this without your permission.
Yes.
This is one of the most dangerous answers a party can give in court. Yes. Not because it automatically clears them, but because it forces the court into a credibility assessment. Either the attorney acted without authority, which is serious misconduct, or the client is misrepresenting facts under oath. Judges do not like being put in that position. Now the court must determine who is telling the truth, and that often leads to evidentiary hearings, sworn testimony, and disciplinary consequences. This is no longer just about housing conditions or lease arguments. This is about ethics. The judge is methodically boxing the issue in. Did you read it? Did you know what it said? Did you authorize it? Each answer tightens the scope of responsibility. And notice how careful Judge Simpson is being. He's not accusing, he's documenting. That documentation matters later. So here's the question for viewers. If your attorney files something without your approval, should the court protect you? Or should it treat that filing as your responsibility anyway?
Believe me, I'm
Have you
staying as far away from
have,
as possible.
did you read the affidavit?
The initial one,
No, I understand the initial one. Did you read this doc?
no, actually, I didn't. I did not.
I did not know.
Updated, I mean,
Updated one.
because I didn't even realize that initially when we submitted it, that we submitted something that had pages mixed up.
Your Honor, they're still responsible for their filings.
Yeah, but I don't know if that's their filing.
She mentioned about the pages being mixed up. Their response to our MSD, they are still responsible for their filings. That's all.
No, I understand that, but I don't know how I hold them responsible for things that were filed without their knowledge, is what they're telling me. That's the difficulty I'm having, right? Is that, procedurally, if Ms. Tope came along and filed this, but had gone to them and said, here, this is, I see what you're saying, so I need to correct this. Here's this, I'm going to file this. That might be one thing, but that's not what I'm hearing here. I'm hearing that this was filed. You guys didn't have any knowledge as to its contents.
Correct. I did know that she corrected it after the fact and submitted it after she did it. I had no idea any implications that would come of that.
You had
I hear
knowledge
now
that she
that
didn't, that she did what?
That she fixed it after the fact, but she never told me that she was
What
Filed
does that
report.
mean? That you had knowledge that she fixed it after the fact?
She told me she did it after she sent it to them, but it was already done. She never asked me if she could do it.
So after, when was that?
At some point after they received it.
Well, they just got it.
We received it Friday afternoon. Even though it's dated on there January 8th.
Yeah, I would have to look. I don't know.
And then
You have to look at what?
My email.
Look at your email. I want to know.
Actually, there's nothing in here, so she must have just told me that she would fix it. If this is any help in understanding my brain frazzle, I also have a case of strangles at the farm.
This moment is almost surreal, and yet it reveals something important. Stress, distraction, and outside chaos do not excuse procedural violations in court. Judges may empathize, but they cannot ignore rules because someone is overwhelmed. The judge acknowledges the confusion, but notice what he doesn't do. He doesn't dismiss the problem. He's still focused on the integrity of the court process. Because regardless of personal circumstances, filings that waste time, increase costs, or muddy the record are unacceptable. This is where courts draw a hard line. Life happens, but litigation requires discipline. If documents are filed improperly, someone pays for that mistake, emotionally or financially. And as we're about to see, Judge Simpson is not done addressing accountability.
What?
If this helps you understand my brain frazzle, I also have a case of strangles at the farm.
Okay.
Your Honor, I would add in the context that Ms. Tope is still representing them in the circuit court action.
Yes.
My understanding was that we were here today to continue settlement talks and that the settlement that we presented on the 6th was rejected.
Right.
Okay.
We might be. And I may have called the parties back and said, look, where are we? I mean, counsel kind of let me know where his client, but the problem I'm having and what is creating a bit of a difficulty here is that there are documents that are being filed in this action, not by you.
Nor with my permission. I don't know how it.
Was there anything recently filed in the circuit court action, counsel?
No, Your Honor. Yes, our witness list. Yes.
Right. Okay. But I mean, anything else by Ms. Tope that was.
I filed my witness list and then she filed her witness list hours after.
After. Right.
I can find that date. But to my knowledge, Ms. Tope is still representing the wards in the circuit court action. And it seems like they are still having communication in this case.
Yeah. And the communication I don't necessarily have a problem with. What I have because I don't know that I could stop that in any way. But what I do have a problem with, so things are filed before this court, presumably on your behalf, but without your knowledge. That just it. And then counsel has to spend time looking at it and trying to respond to something that you guys didn't file. And you don't even know what it is at this point.
Today?
No, it is not valid unless it's ours.
I don't think either one of them said they've seen it before today. Did you see it, ma'am?
We talked about it, that she was updating it, but neither one of us read it.
No. I get that there can be these conversations,
Yes.
right? I mean, and I don't have a problem that she was going to update whatever.
Right.
Have you
No.
seen what was filed in court on your behalf?
No.
Do you know where Miss Tope is right now? Because I'm going to tell you, I'm a bit livid, just a bit.
Can you take that up with her?
Well, I intend to, but here's the problem. Yes, I don't think the parties, and I'll just say this on the record, I don't think the parties were all that far apart in terms of how this matter could be resolved. That's just this court's view. But I also have these motions before me that I need to rule on. But at each, and so we come back here, regardless of what the parties thought may happen, might not, whatever, right? She then interjects herself, and quite frankly, interjects herself in a way that for an attorney to do it, for anybody to do it is a bit appalling. For an attorney to do it is tenfold that.
This is the heart of the ruling's emotional weight. When Judge Simpson says it's tenfold worse for an attorney, he's invoking professional ethics. Lawyers are officers of the court. They are held to a higher standard than anyone else in that room. Filing something without client review, without authorization, or without procedural permission undermines the entire justice system. That's why judges react so strongly to this kind of conduct. It's not just inconvenient, it's dangerous to fairness. The judge is making it clear, if this filing happened the way it's being described, it is unacceptable. And the consequences won't fall randomly. They'll fall where responsibility is proven. This sets the stage for what's coming next. Sanctions, contempt proceedings, and a formal order to show cause. The case has officially crossed from messy litigation into potential disciplinary action.
Because in effect, let's look at it this way. If Ms. Topper represented you, she shouldn't be filing anything with the court that you have not reviewed or she has not gone through with you and you have not seen. But she's now filed something not as the attorney on your behalf, and you have no idea what it is.
I understand. I should have taken her affidavit and had Aaron submit it. That's a correction.
But I'm not going to tell you what you should do because I haven't looked closly at what she submitted vis-a-vis the other part. But you can't respond to her affidavit.
As a witness, I thought, because she was a witness to the
No, but the affidavit is submitted as part of a motion for summary disposition. So if we go forward with the motion for summary disposition, you don't know what that says. Right?
Right. I mean, I have a general idea, but no. Specifically, no.
You don't know what it says.
Correct.
The only general idea you may have is what Ms. Tope in the moment told you she was going to do. But you don't know what it says, do you?
No, not specifically.
So if I have counsel respond to the substance of this affidavit, I just want to be clear. You can't respond to the substance of what's been filed.
This is a devastating procedural dead end for the tenants, and it's entirely self-inflicted. Judge Simpson is laying out a simple but brutal reality. You cannot respond to or benefit from a document you admit you haven't read. That's not just common sense, that's basic due process. In litigation, affidavits aren't casual statements. They are sworn testimony used to influence outcomes. If you don't know what's in them, you cannot argue for or against their contents. And the judge is making sure the record is crystal clear on that point. This also explains why the court is so frustrated. The opposing counsel is being forced to respond to filings that the actual parties disavow knowledge of. That's wasted time, wasted money, and wasted judicial resources, exactly what the judge flagged at the very beginning of this hearing. So pause here and think. If you were the judge, would you allow a case-shaping document to stand when the parties themselves admit they don't know what it says?
Okay.
No, I mean, that was a question.
Oh, I cannot give you the specifics of the substance of what was filed other than it was the affidavit. And I know in general, as a boarder, what happened with her horse and the injuries sustained due to the fencing. and the witness that she is to the collapsing buildings and the fallen trees and the heavy equipment.
But this is wasting the court's
Yeah,
time,
I don't-
and it's wasting plaintiff's time.
I don't need it.
What?
I don't need to talk about it. I thought you were asking me.
Well, the problem is maybe I'm a bit unclear. Counsel receives this on Friday. That requires him to do certain things, increasing the cost to his client. He comes here and then has to spend time in this courtroom making an argument regarding something that you don't know anything about, but are connected enough to the person that filed something on your behalf. That's a problem.
Your Honor, I would just also add, this has been a pattern. We've had hearings set and tenants file motions and send them to me 2 days before the hearing. This is a pattern.
No, I get it. I get that part of it. And most of that stuff we can sort through, but when that was happening,
I think we got the motion for summary judgment the day we were coming in here. No?
well, you may have gotten it, but I think somebody.
Yeah, I had to file it. It wasn't noticed for the same day.
I'm gonna let you go ahead and argue your motion. All right, go ahead.
Your Honor, would you like me to address the affidavit?
Yeah, I knew we were gonna get there. Yeah, I'm gonna let you do your motion. It's a fair question as to whether or not.
Your Honor,
Hang on a second. The court's gonna stand in brief recess.
All rise. County of Washington State of Michigan, to die back confession, the Honorable Judge David.
You may be seated. Back in the case of fixed housing 401k plan versus the wards. Here's what I'm going to do, much to your dismay, because I'm going to give you an 8th date. Okay. An 8th date to come back, an 8th time. But I am adjourning the motions for summary disposition. I am also, after some consultation as to some of the ethics that have been involved, which is why I was taking the rather prolonged break, that I'm going to set an order to show cause for Donna Tope to show cause why she should not be held in contempt for the filing of this. I would just place Ms. Ward, I would place you on notice that you have made a specific representation to this court that you had no knowledge.
This is the nuclear option, and it's rare. An order to show cause means the court is demanding an explanation under threat of contempt. This is not a warning. This is formal escalation. Judge Simpson is signaling that the ethical concerns here are serious enough to require justification on the record. Contempt proceedings can lead to sanctions, fines, or even professional discipline. And importantly, the judge clarifies that this order is not currently being directed at the tenants. It's aimed squarely at the attorney involved. But make no mistake, the tenants are not entirely insulated. If evidence later shows they authorized or knew about the filing, that protection disappears instantly. The judge explicitly puts them on notice. Their credibility now matters deeply. This is courtroom accountability in action. Transparency is no longer optional. February 3rd is now a reckoning date
Of any of that. And so I'm holding to that representation in terms of setting this notice or setting this order to show cause. Counsel for the plaintiff, in the event that the court would award sanctions and or costs, I would need a billing from you, an appropriate billing from you, laying out from certainly the time Friday, time that you received this, what you had to put in to do that, and your work up to that, as well as what other stuff you may have to deal with this being adjourned out 2 weeks to that day. I will then adjourn it for the motions and for the order to show cause to February 3rd at, you wanted me at 2
p.m.
at 2 p.m.
Can I hear again what those two purposes are?
One of the motions that I'd like to rule on at some point, but the other is for an order to show cause as to why Ms. Tope should not be held in contempt of court and or sanctioned.
On that second note, how does that have anything to do with me and?
Oh, it certainly does, because here's going to be part of your problem, as it may be, and that is I will have to make a determination if Ms. Tope gets here and says that that was filed with your full knowledge and authority because you have represented to the contrary. And so I would suspect that when the two of you get here, you're going to be very much at odds.
This may be the most quietly ominous line in the entire hearing. When a judge tells parties they're about to be at odds with their own attorney, it means the court expects conflicting stories. Under oath, that creates enormous risk. Someone will be wrong, and being wrong in this context isn't embarrassing. It's legally dangerous. Judges do not tolerate inconsistent narratives when ethics are involved. The court is also signaling that testimony may be required. That's why subpoenas are mentioned. This isn't casual questioning anymore. This is formal fact-finding, and credibility will determine consequences. If you're watching this unfold, ask yourself, would you feel comfortable being cross-examined about something you didn't read but benefited from? Because that's exactly where this is headed.
So you're going to reach out to her separately, though I don't have.
Oh, no, yeah, we will be sending a little piece of paper commanding her to be here.
Okay. Can I ask one question before you adjourn today?
Yes, ma'am.
Plaintiff's lawyer mentioned that I had reached out with 2 additional complaints, and I just need to understand what my legal process moving forward would be when I have a fence fall over or don't have water, because those weren't additional complaints from the past. Like, I'm still
you
there.
can certainly reach out
I'm
with
just letting you know.
whatever, right, you can reach out with whatever repairs. I certainly would have been in a position to kind of address that today, but I
realize that my landlord is probably not, as usual, going to do anything about it, but I want it documented that, hey, on this date, the wind blew this section of fencing over. It just keeps happening. So that's okay to email him.
you can email him
Okay.
as long as it's you emailing him.
Yeah, it's no motions or anything.
All right.
Thank you, Your Honor.
Sir, was there anything else?
I would just say when you email me, put that it's for this action because Donna Tope is still representing you in the circuit court action. So be clear what you're talking about. Because there are two actions.
So regarding my lease, these things are falling over. Is that correct?
I think what he's trying to say is that you are directing your concern regarding this case,
Right.
as opposed to the case that you are represented by Ms. Tope.
No,
Because
but
presumably,
so
so listen to what I'm saying. That it's regarding this case because presumably if the complaint were to be in that other case, he would be receiving a communication from Ms. Tope.
okay.
I'm trying to make sure I'm following this.
Yeah, right. Because he can't respond to you in a case in which you are represented by an attorney. So you have to make it clear that this is the case you're dealing with.
Okay.
All right, folks. Thank you.
Thank you.
And so that, I guess one other thing, I was not aware of that filing because it had gotten put into the file and there was no judge's copy that was presented to the court. So it did not come to me. But
This case ends exactly where it began, with procedural failure. Documents filed without proper presentation, without authorization, and without clarity. And that's why this hearing didn't resolve the underlying dispute. It exposed a breakdown in process instead. Judge Simpson's rulings are deliberate. He adjourned the motions, ordered a show cause hearing, protected the tenants conditionally, and put accountability squarely on the table. The message is clear. Courts are not playgrounds for sloppy lawyering or unchecked filings. The broader implication here is powerful. Even when substantive claims may exist, procedural misconduct can derail everything. Justice depends on rules, and when those rules are ignored, everyone loses time, money, and credibility. So now it's your turn. Who do you think bears the most responsibility here? The attorney, the tenants, or both? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.